What happens when the people sworn to enforce the law break it? In the United States, police officers carry enormous power. The power to stop you, search you, arrest you, and in extreme situations, even use deadly force. But here's the question most Americans quietly ask: who holds the police accountable when they cross the line? Are officers above the law? Or does the U.S. legal system have real consequences when police break the rules? Today, we're answering that question clearly, legally, and without emotion, using real laws, real procedures, and real accountability mechanisms in the United States. Before we begin, subscribe to this channel for clear, accurate explanations of U.S. law, civil rights, and police powers, so you know where authority ends and accountability begins. Police authority does not come from a badge alone. It comes from the law itself. In the United States, police powers are granted and limited by the U.S. Constitution, federal laws, state laws, court rulings. Officers are required to follow constitutional limits, respect Civil Rights Act within their legal authority. When an officer steps outside those limits, they are no longer protected by the law. They are subject to it. Police breaking the law does not mean every mistake. It refers to unlawful conduct, such as illegal searches or seizures, excessive use of force, false arrest, or unlawful detention, fabricating evidence, perjury, lying under oath, civil rights violations, criminal acts, assault, theft, corruption. The legal system treats these actions very differently depending on severity and intent. Many police misconduct cases begin with the U.S. Constitution. Key amendments involved: Fourth Amendment, search and seizure; Fifth Amendment, self-incrimination, due process; Sixth Amendment, right to counsel; 14th Amendment, due process and equal protection. Example: if police search a home without a warrant and no valid exception applies, they may have violated the Fourth Amendment. This triggers serious legal consequences, even if the officer believed they were right. When police misconduct occurs, several things may happen simultaneously: internal reporting, body camera review, supervisor notification, evidence review, complaint filing by civilians. Misconduct does not automatically disappear. It creates a paper trail. Most police departments have internal affairs, IA, units. Their role: investigate officer misconduct, review policy violations, recommend discipline, possible outcomes, counseling, retraining, suspension, termination. Internal discipline is administrative, not criminal, but it's often the first step. Many U.S. cities use civilian oversight boards. These boards are independent from police departments, review complaints, make policy recommendations, increase transparency. While their power varies by state and city, they play a key accountability role. When misconduct rises to a legal violation, prosecutors step in. Prosecutors may review evidence, decline charges, file criminal charges, present cases to a grand jury. Important fact: police officers do not decide whether they are charged. Prosecutors do. Yes, police officers can be criminally charged. Possible charges include assault manslaughter, murder civil rights violations, federal charges, obstruction of justice. These cases are complex and rare, but they do happen. Under 18 U.S.C. Section 242, federal prosecutors can charge officers who willfully violate constitutional rights. This applies when excessive force is used, rights are intentionally violated, abuse of authority occurs. Convictions can lead to prison sentences, fines, permanent loss of law enforcement career. Most accountability happens through civil court, not criminal court. Victims may file lawsuits for excessive force, false arrest, illegal search, wrongful death. These cases are often filed under 42 U.S.C. Parv. 1983. Qualified immunity protects officers only when the law is unclear. It does not protect clearly illegal conduct. Obvious constitutional violations. Courts ask, was the law clearly established at the time? If yes, qualified immunity fails. Can police departments be sued? Yes. Under certain conditions, cities and departments can be liable if policies encourage misconduct, training is inadequate, violations are systemic. This is known as municipal liability. What relief can courts award? Courts may order monetary damages, medical compensation, emotional distress, damages, punitive damages, policy changes, injunctions. The goal is not revenge, it's accountability and prevention. What about body cameras? Body cameras provide evidence, increase accountability, protect both civilians and officers. Failure to activate cameras can itself lead to discipline or legal consequences. Some cases don't succeed because evidence is insufficient. Witnesses are unavailable. Legal standards are high, burden of proof is strict. This does not mean accountability doesn't exist. It means the legal system demands proof. What should civilians do? If you believe police broke the law, stay safe, document everything, file a complaint, seek legal advice, preserve evidence. Knowledge protects rights. No one, not civilians, not officials, not police, is above the law. That principle is the foundation of American democracy. Police officers serve an essential role, but power without accountability is dangerous. The U.S. legal system provides checks, balances, and consequences. Not perfection, but protection. If this video helped you understand how police accountability works, like this video, subscribe for more U.S. legal education. Share this with someone who believes accountability matters. The law doesn't weaken authority, it defines it.